Should I file with the probate courts? That's our subject today. Stay tuned and we're going to get started right after this. Okay, hi everybody. My name is Kes Stadler. I'm the Associate Broker with Atlanta Communities and a certified probate real estate advisor. I'm your specialist. I can help you through the entire probate process from beginning to end. I have a team and we're ready to get started for you. But let's go ahead and talk a little bit about what probate is. Okay, probate is a court-supervised legal process that gives usually the executor or the family members the authority and the legal right to settle someone's estate. Probate usually involves gathering up someone's assets, looking at their debts, helping them liquidate property, both personal and real property such as in a house, and everything that goes with it. In Georgia, like in most states, probate takes anywhere from 6 to 10 months, but it just depends on how backed up the court systems are at the time. So that's just kind of a rough guide. Okay, the first question people ask is, will probate be necessary? In most cases, yes, but in certain cases, if the decedent didn't have any personal property or assets that really need to be divided, then it may not be necessary. But if there is real or personal property involved, then usually it does need to go through probate. And just to be safe, consult an attorney if you're not sure. I can give you some guidance on that, and I have attorneys that are part of my team that can help you through the entire process. So send me a message. Put something in the comments and let us know if you need some guidance with that. A few examples of common assets that may be involved in probate would be real estate property. And normally I tell my clients to do joint right of survivorship, which joint tenancy is what it's called. So if the husband passes, all the estate, everything goes directly to the wife or vice versa. Another is assets that are outside of the will that have been designated to go to a certain relative, a certain family member. It can even be a friend. Something a lot of people don't think about, but life insurance. Depending upon who the beneficiaries are listed in the life insurance policy, probate may be required for that. And then sometimes probate needs to be involved when you have assets that are held in an irrevocable trust. All right, some people ask me, skipping probate when there's no will. That can be done, but there are a few rules you need to follow. Okay, the certain instances involve if the decedent did not have any real property, if they did not have a will, and if there's really, I hate to say this, but nothing really to fight over, probate may not be necessary. So check with the probate courts and see if they will give you a way around the probate so that it just saves time and trouble, attorney fees. But in most cases, especially if there's assets, real or personal, probate may be necessary. Okay, the personal representative's role in probate. If the decedent specifically names you or someone you know as the executor in the will, then you probably do need to at least present the will through the probate courts. And in some cases you can ask the judge to just appoint someone as an executor. So it can get kind of tricky. This is where it's very helpful to have someone that's knowledgeable in your corner to help you, whether it be an attorney, which is always advisable in certain situations with legal matters. Okay, if you do become the personal representative, you take an oath to follow the probate, follow the will, follow the request of the decedent, and then there's a lot that goes into it. Letters of testamentary is one of the items that we'll discuss, and I'll probably save that for another video because that can get kind of tricky. But if you're court ordered or if you're basically appointed as the executor, you've got a new part-time job, and that's okay. When my mom passed, I was the executor for obvious reasons, and I had my brother and sister involved, but we worked as a team. We really didn't fight over anything, so probate could have been optional, but we did consult with our attorney and just followed their guidance on it. Okay, if no one was named in the will as the executor, then you have the probate court will recommend or basically assign someone to be the letters of administration. And that's different than letters of testamentary, but letters of administration. This document gives the personal representative which could be the executor or like I said, what we call the PR, a personal representative, the ability to do some of the following items. Collect and inventory the decedent's personal and real assets. Have the assets professionally appraised if necessary. That could be for, like I said, an antique dresser, or it could be real estate. It could be commercial, residential, expensive cars, but have it appraised. Another obligation of the PR is to pay debts as they come in, and don't forget taxes. And one of the other things the PR can do is give out the personal assets as stipulated by the will through the probate process. If there is no will, then it may be state ordered on how to distribute the assets. But either way, as the PR, that's part of your authority towards the end of the process. Okay, we've talked about it in other videos, but handling estate assets. When it comes to real property, homes, rental properties, investment properties, second homes, you really need to hire a professional. Get a real estate attorney involved to help with the closing on that. Get it on the market by a licensed realtor. If you're in Metro Atlanta, that's something we can help you with. But you also need to have it appraised. What you want to do is make sure that all the beneficiaries feel like they're part of the process. Keep them up to date on what's going on. And also make sure they feel like they've been treated fairly. Everybody just wants a fair shake and wants to be fairly represented and fairly treated in this process. Okay, another thing the PR will do and part of the process is open maybe a separate bank account, separate checking account. That way bills, liabilities can be paid for, such as taxes or utility bills if the home is nearby, or you want to keep utilities on just to be safe. So that's something the PR can do, is go ahead and set up a separate account. If you as the PR have the funds, you can go ahead and pay these bills as they come in and they get reimbursed by the estate. If you don't have the funds, then talk to your attorney. There's a way you can make it happen. If you don't have the ability to pay the bills as they come in, you can do that through the estate. Okay, and as I was just saying, if you don't have the funds, if you need to sell some personal property or assets to pay all these debts, don't just arbitrarily go out and sell things. Make sure you get it approved by the probate court or by the real estate attorney, so that way you're protecting yourself and you're protecting the estate. Okay, another part of the probate process is dealing with debts and taxes. Within 60 days of the decedent's passing, the PR must advertise in the paper about the estate and basically ask for all collectors. That's their chance. If they have a collection against the estate or against the decedent, that's their chance to come out of the woodwork and file a claim if need be. And as PR, this is part of your obligation, is to work with the attorney and definitely do that by the book. You don't want to have any issues. I've had clients before that didn't follow the right protocol and it really came back to be a big mess. They got it resolved, but attorneys wound up getting involved, and it was just added an extra 6 months of headache and stress on top of an already stressful situation when a loved one passes away. Another question that people ask me is the PR, how do we handle state, federal, local taxes? And you as a representative, that is something you have to deal with. And make sure you don't forget state, federal, one or the other. So that way the estate is clean and clear when you're ready to go ahead and distribute funds and finalize everything. You don't have any last minute gotchas coming up. Something a lot of people ask me about is a federal estate tax return. And that's not really normally required unless we're talking a larger amount. And if we are talking larger money, then you obviously would want to have a professional help you through that process. Don't try to wing it. Whether it's $10,000 or $10 million, I don't recommend winging it when it comes to this, but definitely if there's larger money involved, because beneficiaries come out of the woodworks, and keep the probate courts off your back by doing it strictly the way they recommend doing it. And as PR, that's part of your job. Okay, last but not least is distributing property and closing the estate. The PR, which might be you in this case, can only distribute assets once all the debts and taxes and everything else has been settled with the estate. That's critical. Make sure everything else is settled before you just start distributing any item. But make sure you follow that strictly by the book. I know I keep saying that, but got to be careful. And one other thing, as the executor of the PR, you're going to want to do is have a real good account of everything that's being distributed. Make sure you have that well organized, well filed before you start distributing any personal assets, money, or anything else, or even real property. Make sure that's all documented very carefully and very meticulously done. That just protects you, it protects the estate, and keeps the probate court and the system off your back, making sure you've done it right. Okay, and last, once you as the PR or executor have filed all the necessary paperwork with the probate, you've handled the debts, you've handled the taxes, then you can go ahead and file a request to go ahead and disperse property, which basically gives you or the executor, whomever might be in charge through the probate system, the legal authority to go ahead and distribute the assets. One thing through the courts is the court will look it over and make sure you as executor or PR have followed all the rules, done everything by the book, and then they will go ahead and authorize you to be allowed to distribute all the assets. So make sure if you're going through the probate system that the judge and the courts sign off on it before you start doing it. All right, and then once you have followed all the rules, done everything you're supposed to that we talked about on this video, then you as the PR executor are released of liabilities. As long as you followed the probate courts, what they say, what the will says, what the judge might say, then you're protected. So make sure everything is well documented through the whole process. Okay, I hope you found this information to be helpful. This is just the tip of the iceberg. There's a lot more that goes into it. So if you'd like more information, send me a private message and be sure to like and subscribe to my channel. I give a lot of good information about residential real estate, about the probate process, how to become an executor, everything that goes in it. And lots of videos. If there's a certain video you want me to put together, just let me know. But as always, thanks for tuning in. Have a great day and take care.